Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 159. I'm happy to confirm that there is no truth whatsoever in the rumour that I record this at the Pizza Express in Woking, which in all other respects is a fine dining establishment which I visited a number of times with my family. We're going to depart from normal practice in this episode. There is going to be, I think, an enormous focus on the provisions of IR35, the so-called intermediaries tax legislation, for all of us. And we've got two significant cases from tax tribunals in this episode. And as a result, I thought it was worth spending a little more time going through them in detail, given this is an area of law which, as I say, I think we're all going to be grappling with over the next few months and indeed the next few years. Please don't forget, as usual, podcasts on iTunes, Mayer Brown website, YouTube, Twitter, Spotify, Google Play and Yahoo. And all good news agents. Okie doke. So, Krista Ackroyd Media Limited and the Commissioners for Her Majesty's Revenue and Customs. As most of us already know, the law in relation to the intermediaries tax legislation, usually known as IR35, is being extended. Amongst other key changes from April next year, the risk, where it is found that tax has not been properly deducted, is going to lie, in many cases, with the end user. This makes the whole IR35 issue a much more pressing concern for companies that make any use of contractors via an intermediary company. Against that background, any case dealing with the ambit of IR35 and the intermediaries legislation is obviously of importance. Moreover, I think the Krista Ackroyd case, this particular case, is a worrying case for taxpayers, and it's one that certainly, if you're going to be involved in advising in this area, you need to read in full. So, this is a case where there was an appeal to the Upper Tax Tribunal from a decision of the First Tier Tribunal. Krista Ackroyd Media Limited, CAM, is the personal service company for Krista Ackroyd, who is a television journalist and presenter. Since the litigation relates to IR35 as it's currently enacted, the burden for any unpaid tax fell on her service company rather than the BBC, with whom her service company had a relationship. However, in other respects, the way in which the tax tribunal decided whether or not there'd been unpaid tax is going to be of considerable significance to companies who are making use of contractor services and are trying to plan ahead for April 2020. Background was that there was a fixed-term contract for 7 years running between May 2006 and June 2013, and the amounts at stake were considerable. The income tax and national insurance determinations being claimed by HMRC came to approximately £420,000 over those 7 years. The legislation for tax purposes is set out in the Income Tax, Earnings and Pensions Act 2003, and the key provision is Section 49. The intermediate legislation, it says, applies where, quote, an individual, the worker, personally performs or is under an obligation personally to perform services for another person, the client. B. The services are provided not under a contract directly between the client and the worker, but under arrangements involving a third party, the intermediary. And C. The circumstances are such that, if the services were provided under a contract directly between the client and the worker would be regarded for income tax purposes as an employee of the client or the holder of an office under the client. Section 49.4 goes on to say that the circumstances referred to in subsection 1c include the terms on which the services are provided, having regard to the terms of the contracts forming part of the arrangements under which the services are provided. So, in other words, the issue is if the services were being provided directly, but were being provided in a way consistent with the contracts which are actually entered into, would the individual be an employee? The test for national insurance contributions, and in particular employers' national insurance contributions, is materially similar to the ITEPA wording, which I've just read out. The key difference is that where national insurance contributions are being considered, there is no equivalent to section 49.4. So although the court is asked to construct a hypothetical contract directly between the client and the worker, it is not directed to include the circumstances in which the services are provided having regard to the terms of the contracts which were actually agreed between the parties. It's not clear to me to what extent that is actually going to make a practical difference, as it seems to me those contractual terms obviously ought to be taken into account, but no doubt there will be learned debate on this point. Anyway, in neither of the two cases, neither of them did either of the HMRC or the taxpayer try and argue that the national insurance position was different to the income tax position on the facts. So, what's the purpose of the legislation, I hear you say? Well, the purpose is that where individuals would be paying income tax and NICs if they were employees, that is not defeated simply by inserting a corporate structure to ensure there is no direct contract, between the individual and the end user, the client. And on that basis, the purpose of introducing the corporate structure is so that the individual cannot be an employee, and therefore there cannot be income tax payable or NICs payable. Well, the IR35 legislation sets up a statutory hypothesis. You're asked to assume the services in question are being provided under a contract made directly between the contract and the worker. In other words, that the legislation takes out the easiest way of defeating a claim for employment status, i.e. there is no direct contract, and so there is nothing that could be an employment contract. So if there was a direct contract, would that hypothetical contract be regarded for income tax purposes as a contract of employment? That's the question IR35 asks. If yes, the legislation applies and tax is payable. Please note, of course, this has no impact on whether or not an individual is actually an employee for any non-tax purposes. Things like unfair dismissal are entirely unaffected by IR35. The legislation only has an impact as part of the tax regime. The Upper Tax Tribunal, considering Christopher Ackroyd's case, referred back inevitably to the test for employment status laid down in the Ready Mixed Concrete case back in 1968. And the three elements of the test for employment status. Is there a mutuality of obligation? Is there control by the alleged employer of the alleged employee? And then, are the other circumstances consistent or inconsistent with there being an employment contract? Here, it was accepted that there was a mutuality of obligation. There was a duty of personal service. The surrounding factors, the third condition, were accepted as being largely consistent with employment status. So the whole appeal turned on the issue of whether or not there was sufficient control over Christopher Ackroyd's activities for the BBC in favour of the BBC. The first tier tax tribunal had said the issue was whether or not the work was in fact done subject to day-to-day direction and control, but whether in fact supervision was possible because ultimate authority over the individual who was performing the work resided with the alleged employer. If there was a genuine contractual right to control, then it did not matter whether in practice if that right was rarely exercised. The first tier tax tribunal made a number of findings in deciding that sufficient control did exist. For example, Cam had control over Ms. Ackroyd's working activities. She did not have day-to-day editorial control over her work. Whilst the contract between Cam and the BBC was silent on who had ultimate control, the first tier tax tribunal found that the BBC editor in question would have control over the content of what Ms. Ackroyd was doing. It could decide which stories were covered, in what order. They had a first call on her services. She could not provide her services as a television presenter or broadcaster anywhere else in the UK or the Republic of Ireland without the BBC's consent. When it came to setting up the hypothetical contract, which of course what the tribunal was being required to do here, the tribunal said the hypothetical contract would also be for a term of 7 years. She would be contractually obliged to perform the services, the BBC would be obliged to pay her. If it did not call on her services, it would remain liable to pay her fees. The BBC would be entitled to edit her contributions as they saw fit, and she would have had no right to provide a substitute to perform her work. Based on the existence of the statutorily applicable editorial guidelines for the BBC, the first tier tribunal accepted if the BBC considered she was breaking those editorial guidelines, then it had the power to direct her to comply. On that basis, the first tier tribunal was satisfied the BBC did have sufficient control over what work she did and how she did it to qualify as a hypothetical employee. As I say, the appeal to the upper tax tier tribunal was limited solely to the issue of control, and the appeal was on the basis that the hypothetical contract should conform entirely to the contract which CAM and the BBC actually had, where there was no clause relating to control in it. Additionally, Ms Ackroyd said, there was no basis for including within the term of the hypothetical contract an implied contractual control clause. Ms Ackroyd attempted to argue the court's task should, in these circumstances, have been limited simply to looking at the contract between her service company and the BBC. There was a whole agreement clause in that document, she said. There was no suggestion that there were sham arrangements involved, or that the terms of the document did not reflect the reality. Therefore, since that contract contained no express term, the first-tier tribunal should have concluded there was insufficient control for employment purposes. The upper-tier tribunal accepted it was right to start with the terms of the actual contract as between the service company and the BBC. But, they said, Section 49 of the ITEPA explicitly required the tribunal to look at the surrounding circumstances as if there had been no service company involved. Therefore, it was entirely appropriate for the first-tier tribunal to look at terms not set out in the contract to see if they would have been set out in the event of a direct contract. Similarly, terms set out in the framework agreement or service contract between the service company and the BBC might not appear in the hypothetical direct contract. There was also an attempt by the taxpayer to argue there was no basis for implying a right to control into the contract because the tests for implying a term into a contract were not met. However, the upper tier tribunal disagreed. They said this was not so much implying a term into a contract, but construing the contract itself. On that basis, the upper tier tax tribunal held that the first tier tribunal had reached a reasonable conclusion as to where the ultimate right of control lay, and the appeal was dismissed. So why is all this significant? Well, the short answer is that the issue of identifying a hypothetical contract is hardly a straightforward one. Here, the contract had a duty of personal service, but in practice, the individual seems to be left significantly to her own devices in determining how she performed the services on behalf of CAM for the BBC. There was no clause, remember, in the CAM-BBC contract saying that the BBC had control over her. Even in circumstances, however, where it was not being suggested by HMRC that the contract failed to reflect the realities of the situation or was some other sort of sham arrangement, the effect of the tribunal's decision is to determine that a direct contract would have had a sufficient degree of control in it to amount to an employment contract, notwithstanding the absence of that clause in the actual agreements. I think this is going to be quite a difficult point for alleged employers. Many contractors will be given a degree of latitude with respect to their expertise. However, at the end of the day, the alleged employer could direct them because ultimate authority resides with the employer. Then if this is the case, that may be a sufficient degree of control for this element of the test to be met. Clearly, in other circumstances, there may be no mutuality of obligation. It seems that the surrounding circumstances here, the third element of the test, in ready-mixed concrete, were not inconsistent with employment status, which is why it all turned on the extent of the control. But I think the case does indicate that the legislation is going to give HMRC and therefore tax-tier tribunals quite some leeway to determine whether something would or would not be an employment contract in a hypothetical world. I'm sure we've not heard the last of this case. I don't know if it's being appealed further, but it's certainly going to be cited on many occasions. So that's Krista Ackroyd, Media Limited, and the Commissioners for Her Majesty's Revenue and Customs. So now we have Canal Street Productions Limited and Commissioners for Her Majesty's Revenue and Customs. Well, having looked at the previous case of Krista Ackroyd, which came out a couple of weeks or so ago, we've had a second IR35 case involving, amazingly, another TV presenter who seems to have worked on precisely the same sort of programmes as Krista Ackroyd. I think the second case is at least as significant as the Krista Ackroyd case, and in some ways might be more significant. Canal Street Productions Limited was a company set up and managed by the TV presenter Helen Foxborough. Under the IR35 legislation, she was assessed for tax and NICs of slightly over £80,000 in respect of her work for ITV. The first-tier tribunal, tax chamber, allowed an appeal by Canal Street Productions against HMRC's assessment, and that's the decision that we now have the report of. I think their reasoning is really interesting. It's a long judgment. It repays careful studying, and I think it's really clear. The issues in front of the first-tier tribunal were easy to spell out. There was no dispute that Ms Foxborough was under an obligation to perform services personally. There was no question of a substitute. Secondly, the services were not being provided directly. They were being provided through a corporate intermediary, Canal Street Productions Limited. The only question, therefore, for the tribunal was, of course, the key one. If her services were being provided under a contract directly between ITV and her, then would Ms Foxborough have been regarded for income tax and NIC purposes as an employee of ITV. Having worked for 15 or so years in media, Miss Foxborough set up Canal Street Productions Limited in 2002 for the purposes of an engagement with the BBC. She left the BBC in 2004 but kept Canal Street Productions Limited going. It was her business vehicle. She had various on-screen assignments, relief news presenting jobs and presenting work for a range of corporate clients, hosting awards ceremonies and the like. She engaged agents on behalf of Canal Street Productions to seek broadcasting work for her, voiceover work and other work. She was also on her list of targets that the agents were trying to get. After Canal Street Productions Limited had been running for 7 years, she started to work for ITV from about 2009 on a casual basis, with fees being negotiated on an engagement-by-engagement basis. However, from 2012 onwards, there was a series of 3 framework agreements put into place between Canal Street Productions Limited and ITV relating to the provision of her services. The court, the tribunal I should say, analyses each in turn as to what was the obligation on Canal Street Productions Limited to secure the services of Miss Foxborough, and was there an obligation to provide work and undertake work in the framework agreements. The tribunal decided there was no obligation on Miss Foxborough or Canal Street Productions to accept any work offered to her by ITV, or for ITV to provide any work to Canal Street. There was evidence indeed on occasions of her having accepted work elsewhere, and then when ITV turned up and offered her some work, she'd simply turn them down without any adverse consequences. There was no express obligation on ITV to offer work. There was no obligation on Canal Street to accept it. Although in practice, having entered the framework agreements, she did many more days' work for ITV than was originally anticipated under the contract, the tribunal accepted that this increase was not a result of any prior agreement. It just happened. On that basis, the judge, in summary, says that the framework agreement set out the terms that applied to each engagement, but there was no obligation between engagements for ITV to offer work, or for Ms Foxborough to undertake any work for ITV, and there was no binding agreement to that extent unless and until a particular engagement was made by ITV and accepted by Canal Street. Then the framework agreements kick in and the pre-agreed terms applied. It's true, there were restrictions on Canal Street Productions and therefore Ms Foxborough. In between engagements, she was restricted in relation to some of her other broadcasting activities and in relation to certain non-commercial matters, such as an obligation on her to maintain her health and not engage in dangerous sports activities. The evidence showed that Canal Street Productions' largest client by far during the relevant period was ITV. Somewhere between 61% and 72% of its total income came from ITV, but during that time she also worked for between 10 and 20 other clients. Bearing in mind as well that Canal Street Productions had engaged agents to obtain work for her from other sources, it was clear that she was looking to maintain that area of her business. The judge then turns to consider the terms of the hypothetical contract which the judge would have envisaged would have applied. The judge determines that the agreement, if it had been concluded directly, would also have been a framework agreement. There would have been no guarantee of any work, nor obligation on her to accept work, but if work was offered and accepted, she would be obliged at that point to perform the work personally, and ITV would have had to pay for it. ITV would have been able to choose where and when the services were provided, and would have had full editorial control over any programme. She would be precluded from engaging in any new commercial activities without ITV's consent, and there would be the same restrictions on her activities between engagements as existed in the framework agreements, stuff about her health, for example. So then, coming to the main question, would this hypothetical contract have made her an employee? I think it's here that the really quite significant elements of this case become apparent. HMR conceded that the 3 framework agreements by themselves, if they had been entered into directly with Miss Foxborough rather than her company, would not have amounted to employment engagements. And I think that's clearly the right thing to say, because there was no obligation on her to accept any work, nor ITV to offer any work. However, HMRC's argument was that once she'd accepted an engagement offered under that framework, accepting that obligation was then sufficient to create an employment assignment during the lifetime of that particular task, and that in turn triggered IR35. To put it another way, during the operation of those assignments, she would have been viewed as an employee for tax purposes. Inevitably, the judge refers back to the Ready Mix Concrete case. The tribunal sets out the tests of mutuality and control. The court also considers the element of the third test, i.e. the other provisions of the contract are consistent with it being a contract of service. The court accepted that if there is a sufficient control and sufficient mutuality of obligation, then there will be a contract of employment unless the other provisions of the contract are inconsistent with it. This clearly places a significant premium on the issues of mutuality and control, and in turn makes what happens in this case perhaps slightly more surprising. Tribunal determines there was sufficient mutuality of obligation during the hypothetical individual engagements. The tribunal determined that once she'd accepted the engagement, she'd be contractually obliged to do it in return for a contractual fee. She'd be obliged to provide the services personally, she couldn't send a substitute, and if she got ill, ITV would find the substitute presenter, not her. That is sufficient, the tribunal said, to create mutuality of obligation. 1 down, 2 to go. Secondly, in relation to control, the court accepted she would have had a degree of autonomy. However, the tribunal said the key question is whether the putative employer has, to a sufficient degree, the right of control over the worker. The key question is not who exercises day-to-day control, particularly in the skilled worker, but where the ultimate right to control resides. They cited with approval a Supreme Court decision which said, quote, "The significance of control today is that the employer can direct what the employee does, not how he does it." In this case, it was accepted by the tribunal that ITV would have had little control over the actual performance of Miss Fossborough, but ITV controlled where and when services were provided and editorial control over the programmes. It had contractual rights to direct what Miss Fossborough did and to sanction her by withdrawing further work for an inadequate performance. That is sufficient. So at this point, Miss Fossborough is 0 for 2. However, the tribunal then looks at the third condition, the other relevant factors. Tribunal accepted that it is a relevant factor that there was no obligation to provide or accept work between engagements. The tribunal accepts you can still have an employment engagements during the engagements that are actually accepted, even if there is no work-related obligations between those engagements. But overall, the court takes the view that the circumstances in Miss Fossborough's case justified the inference that she would be working as an independent contractor rather than an employee under the hypothetical contract. The obligations between engagements do not detract from the inference that she was self-employed, they said. In essence, these were the requirements. There were requirements placed on her to maintain her place on the list of preferred suppliers for ITV and to ensure that she was fit and able to perform the services if requested to do so. The sanction on her was not a disciplinary one. It was simply a sanction that if she broke those obligations between engagements, ITV wouldn't engage her again. So, the tribunal then went on to consider that it was appropriate to look at the arrangements under which she provided her services during that time as a whole. In other words, it stood back and looked at the bigger picture as to what she was doing with her time generally. Here, it was important the arrangements with ITV were only part of the wider business carried on by her through Canal Street. That business had been in existence before she started work for ITV, continued after she ceased to work for ITV. She was seeking other work as well for the company throughout that time. The fact that ITV was an important client did not detract from this. Small businesses are often significantly exposed to a particular client for a particular period, the court said. For that reason, the tribunal here said it would be, quote, artificial to isolate the relationship with ITV and that period of time from the remainder of the business carried on by Miss Fossborough, unquote. Secondly, Canal Street Productions and Miss Fossborough incurred costs and expenses in relation to Canal Street Productions. For example, she purchased and used her own equipment. She engaged agents to source work. Thirdly, it was a clear intention on all parties that she was not to be treated as an employee. The arrangements with employed ITV presenters were very different from the arrangements which would have applied to Miss Fossborough and would have been applied in the hypothetical contract. For example, the employed presenters had laptops provided to them, ITV email addresses, workstations, rooms at ITV studios, and more generous expenses allowance. Finally, the judge stood back and took a look at all this and pointed out these were a series of short-term engagements for ITV. Ms. Fossborough had no guarantee of further work and ITV had no obligation to provide it. I do think it's also relevant that, as the case identifies, her engagements were specific engagements often lasting for a few hours rather than for months or years at a time. One of the questions we've been discussing within the employment group is the extent to which a tax tribunal would look at individual assignments accepted under framework agreements. These are, it seemed to us, far easier to argue as being fitting the bill of a hypothetical employment contract, because clearly once you've accepted a piece of work under that assignment, then the obligations, if you like, have crystallised. We were unclear how the tax tribunal would look at it. Here we have an answer. The tribunal in this case stood back and looked at the overall arrangements that were going on, rather than just focusing on the hypothetical arrangements with ITV. Given that the individual on the facts of this case was clearly in business on her own account, based on her external activities, I think the tribunal's approach makes perfect sense. It does mean that individuals, however, who are tied into one particular client are going to be more at risk of having IR35 applied to them. And therefore the customer is going to be more at risk of having to pay income tax and national insurance contributions. Here, in circumstances where an individual was getting 30% of her income derived from commercial activities for clients other than ITV, you would have thought it was relatively clear that she was in business on her own account at the relevant time. Provided other courts and tribunals take the same approach, i.e. do not just isolate the ITV contracts on its own, then this does offer a degree of comfort for customers and users. I think the key question, however, is whether another court or tribunal will accept that, when looking at the third of the ready-mix concrete factors, a court or tribunal is right to say that it can take into account extraneous factors outside the scope of the hypothetical contract. Is the tribunal in this case right not to isolate the ITV contract? I suspect there's going to be some further litigation on this particular issue, but let's see. So that's the case of Canal Street Productions Limited and Commissioners for Her Majesty's Revenue and Customers. So, thank you very much indeed for listening. It only remains for me to confirm that Boris Johnson has not been involved in any way in our application for public funding for this podcast. Take care. Look to talk to everyone again soon. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.